So now these are our overarching concepts for everything in Unit 3, the principles of justice. Now we're looking at the criminal justice system specifically, okay? And then we'll look at civil. So first of all, the burden of proof and the standard of proof. You need to be able to define what these concepts are, and they are different in the criminal and civil justice system. So you need to be able to state that difference. So the burden of proof is the obligation of a party to prove a case in court. Basically, which party has to prove that the other party did something wrong, okay? So that's why it's called a burden. It's the burden that you have to prove someone did something wrong. So, as we can imagine, in the criminal justice system, the parties are the prosecution and the accused person, which is also referred to as the defendant. Okay? So, it makes sense that the prosecution, which is literally the state, the state's uh, hired lawyers and staff trying to prove you did something wrong. So the prosecution has the burden of proof because they're the ones with more power because, because they're literally the state trying to get someone put in jail. And because they're the ones initiating a claim, basically. They're not exactly, it all happens with police and stuff, and the police charge the person, but in a nutshell, it makes sense. The prosecution, right, would have the burden of proof. As the accused person, I've been accused. Why would I have to prove that I'm innocent? Why would I have to have the burden of proof? That doesn't make any sense. So the prosecution has the burden of proof. Now, the standard of proof is the degree or extent to which a case must be proven in court. I never really like this definition. When I define standard of proof, I like to say something along the lines of the strength of evidence or the level of evidence that is required for the case to be successful or for the case to be proved in court. Okay, so the strength of evidence that is needed. And that's the standard. So if you connect burden to, oh, I have this obligation to prove that the accused is guilty, if you connect standard to, a high standard, the strength of evidence that is needed, maybe you can just make sense of these terms without having to rote learn anything. But it's beyond reasonable doubt in the criminal justice system. You need to be able to explain what that means as well. But basically, beyond reasonable doubt is a very, very high standard of proof. And it means that there needs to be no doubt as to whether the accused is guilty whatsoever. No reasonable person, after seeing this whole trial, would still have room to doubt whether the accused person is guilty or not. Okay, they would all be convinced. So, next concept that we're looking at is the rights of the accused. And one of these is changed by the study design, but it's actually changed to something a lot easier, which is just the right to silence. Previously, it used to be the right to a fair trial, which included many processes within the definition. So we'll just skim through these. I do have like sections and whatnot here, but you don't really have to know these. It's great if you can. So the accused has a right to be tried without unreasonable delay, to have their trial fairly soon. So this is defined as the right to have one's charges heard in a timely manner. And it states that delays should only occur if they are considered reasonable. So this right acknowledges that delays will always occur within the justice system. Of course, we have case backlogs, okay? But they cannot be illogical or unreasonable. So if all criminal cases in this specific court are getting delayed by a year until the trial finally happens, that's probably reasonable. But if for this one person, that's 3 years that they have to sit without any release on bail, literally sit in jail, that's not fair. So we have this right to be tried without unreasonable delay. We've got the right to silence. This is a common law, actually. It's been developed through the courts, but it basically suggests that a person who's been accused of committing a crime has the right to silence at all times to avoid incriminating themselves. So they have rights like refusing to talk to police and give a police interview, and refusing to talk at all during a trial or even to give any evidence. This is used again when an accused person doesn't want to incriminate themselves, because who has the burden of proof? The prosecution does, not the accused. All right. And then we've got right to a trial by jury, which is for all indictable or serious offenses in the criminal justice system. The accused person has the right to a jury trial with 12 members of their community deciding whether they are guilty or not, rather than a single judge. So, trial by jury involves members of the community being impaneled to listen to the facts of the case and determine the verdict. This is supported by Section 80 of the Commonwealth Constitution and is only accessible, again, to those charged with an indictable or serious offense. So, if you've been charged with an offense and your claim is going to the magistrate's court, which is the lowest court in the court hierarchy, you are not entitled to a trial by jury, because that is a summary or not serious or not very serious offense, okay? So we get access to a trial by the community. You will need to learn the Constitution in Unit 4, so you do need to remember that Section 80 of the Commonwealth Constitution gives us right to a trial by jury for indictable Commonwealth offenses. Okay, but this is only for Commonwealth offenses. Things like terrorism, large-scale fraud, things that are tried as a Commonwealth crime in the High Court, a crime against all of Australia, okay? And then within the states, there is state legislation, such as a Victorian piece of legislation that also ensures the right to a trial by jury, okay? So there are different pieces of legislation that ensure, but for Commonwealth offences, it's Section 80 of the Commonwealth Constitution, and you will need to know this section later on when you learn about express rights later on in the year. Oh, sorry guys. Don't know why it's taken me down there. All right. All right, so those are the rights of the accused. When we look at the rights of the victim, look at this in a bit more detail because it's less self-explanatory. They're supported by the Victims Charter Act 2006. That's just optional to know. And the few that we have is the right to give evidence as a vulnerable witness. The study design is now calling it the right to give evidence via alternative arrangements, but it's the same thing, okay? The right to be informed about the proceedings, obviously that means the trial and what's happening, and the right to be informed of the likely release date of the accused person. So just a different format, alternative arrangements, being informed about proceedings, and being informed about the likely release date of the accused. So we'll start with the vulnerable witness / alternative arrangements one first. Basically, this right allows victims that are considered vulnerable to access certain ways to make it easier for them if they have to appear in court as a witness and give evidence. It tries to protect them and make the process easier for them, less intimidating and whatnot. So what kind of victims of crimes would be vulnerable? Some great examples are if it's a child, so anyone under 18, if there is some kind of disability, especially any cognitive impairment, and victims of certain crimes. So if it's a crime where, the accused person has actually physically hurt the victim, maybe sexual offenses as well as violent crimes, all of those things could lead that witness to be deemed vulnerable and grant them access to those alternative arrangements they can use in court. So, some examples of extra provisions: one might be having a support person when giving evidence. We can imagine that being the case for maybe the child under 18. Having a support animal is one as well. Um, they might try to make the court less formal by getting all of the legal personnel to disrobe and take off their formal wear, like their wigs. Or, for example, the vulnerable witness might be giving evidence through a short circuit TV in a different room, or they may just put a screen down so the victim doesn't have to see the accused or see the court, and the accused cannot see the witness either. Just giving you a different way. A couple other points mentioned. They could even close the court to the public. Maybe you've seen this, noticed this in some kind of movies and stuff, where a child is the vulnerable witness and the child is like the only, and the child and the prosecution side and the accused side, they're the only people in court when the child is like giving a statement and being cross-examined later on. Okay, so the other rights of victims. Everyone as a victim has the right to be informed about proceedings. To define this means being entitled to information regarding the investigation of the offense and the prosecution of the accused, and having court processes explained to them. So, the ability to understand court processes is one, and being kept up to date with any information about the trial in a nutshell. It's supported by a few different sections of the Victims Charter 2006. And basically, what's happening when you need to explain this right for questions, the prosecution might actually sit down with victims and tell them about any developments in the case. For example, that they're going to proceed with a plea negotiation, potentially giving the accused a chance to plead guilty early on in the trial, for instance, and finish the trial, um, and other information to update about. So here's a more complete list. It could be the details of the charges made against the accused that the victim is informed of. So that means what exactly the accused person has been charged with, what crimes, okay? If no charges were made, why that was the case, how the victim can get the date, time, place of any of the hearings or the trial if the victim actually wishes to attend. Uh, that might be due to like wanting a sense of retribution, seeing justice being served. And then the outcome of the trial, the prosecution must also inform the victim of. So whether the accused was found guilty or not guilty or acquitted, just let go. And the details if there's any appeal challenge to the original decision. Okay, and our last one is the right to be informed about release date of the offender. So victims of crime are entitled to be informed when the perpetrator of a crime against them specifically is likely to be released from prison. So this is not one of those automatic rights that all victims have. You need to fit a certain profile as a victim in order to have this right to be informed about the accused person's release date. So this criteria you need to know. The victim needs to be on the victim's register. This means they need to be a victim of a certain heinous or violent or sexual family violence crime in order to be informed about that release date, okay? Only being a victim of one of these types of crimes or having a certain relationship with the accused can put someone on the victim's register so they receive this entitlement. And it can only apply, of course, as I've just explained, to certain offenses. So those usually involve assault or injury punishable by imprisonment. So that could be you know, those really violent or crimes of a sexual nature. And the way this right functions is the victim of one of these crimes that's on the victim's register will know at least 14 days before the accused person's release that they're going to be released. So, what information does it allow victims the entitlement of? You do need to know these as well, but it's the length of the prisoner's sentence. What is their actual sentence? How long do they have to be in jail for? The prisoner's earliest release date. So they may be released on parole. You'll hear a bit more about this term throughout the year, but their earliest release date would be the one they may be released on parole, or if they don't get released on parole, it will just be the length of the prisoner sentence, okay, that they have to serve in full. If they have been released on parole and they have been released at their earliest release date, the victim must be informed of this as well, and whether the prisoner has escaped. That would be very rare. But yeah, that summarizes this right. Okay. Now we look at the organizations and alternative dispute resolution bodies we have within the criminal justice system. And we'll start with Victoria Legal Aid, which is a Victorian organization. And I'll call it VLA for now because it's shorter. Um, so VLA aims to create a fair and just society where every Victorian's legal rights are upheld. It's a government-funded organization that aims to give legal representation and legal aid, which means financial support as well, or duty lawyers, free lawyers. This is more rare, to accused individuals in Victoria who would otherwise be unable to access these services. So the roles that it has is giving that legal aid. So people who have very low income, and let's say I have very low income and I've been charged with an offense and now I have to go to trial, I may seek out VLA's help to give me a financial grant, to give me money, or to give me a duty lawyer, give me a free lawyer to help represent me in court. But because it's government funded, it's always underfunded. So you need to be like a really low income earner to have access basically to VLA. Other roles, it tries to manage its resources to make legal aid available at a low or reasonable cost. So they also give partial cover, and they provide improved access to justice and remedies. Obviously, they have other roles like just giving free legal information, giving free legal advice. That might be case-specific advice. What can you do to ensure the best chances of your success at trial? They might let you actually consult with someone and tell you. So you need to be able to know each of these roles and explain them in questions. So free legal advice, free legal information, duty lawyer services, and a grant of legal assistance. So free legal advice is what I've just talked about. It's either case specific or it's not. So helping that person with their particular case and telling them what their options are, how can they ensure their best chances of success, or just general advice. Okay, free legal information might be accessed over the phone or VLA's internet website, tells people about the court system and their rights, etc. Duty lawyer services, giving free lawyers for people that do not have access to legal representation if they don't have money, and they meet their income test, they have a very low income. And the grant of legal assistance is, again, you need to meet an income test, have a low enough income to basically be given money that you can use for court processes. Now, community legal centers are another organization you need to know about. Their purpose is to provide accessible, efficient, low-cost legal services and advice to the general public on a wide range of criminal and civil matters. Really, both of these are bodies that are within the criminal and civil justice system. VLA has more roles within the criminal justice system, however. It usually helps people in the criminal justice system rather than civil. CLCs help everyone as well, criminal and civil matters. It's more spread out. They're legal centers within the community, exactly as the name says, but their roles are similar to VLA. They provide legal advice and potentially representation at low or no cost. Okay, so a key difference with CLCs and VLA is that CLCs don't usually give legal representation or free lawyers to people, but they do have a lot of legal advice and information. Okay, they also play a role in education, um, and they're split into two different types. So there are generalist CLCs. This means you can access the CLC based on the geographical area. So let's say you live in a certain suburb and there is a CLC in that community. That CLC will give its services to you because you are part of the same geographical area that it helps people in. And they're also specialists. They're based around the group of people or the type of law. So specialist CLCs will help people either dealing with a certain type of the law, such as family law, um, or a certain group of people, such as Indigenous and Torres Strait Islander people, might be held by a specialist CLC. Okay, so that's everything. So these two bodies you learn about in a lot of detail, and they're very common questions. Now we'll have a look at plea negotiations. I mentioned this word previously, so we'll also define it for everyone. But plea negotiations are discussions between the prosecution and the accused person where they're trying to get an early way to finish the trial by making the accused essentially plead guilty to avoid the trial dragging out. So the purposes of it are to save time, resources, and money for the courts and for the prosecution. By finishing a trial early because the accused pleaded guilty, it helps to reduce backlogs and saves a lot of time for other cases that need to go to trial. It provides certainty. The accused should only plead guilty if they really did commit the crime. So it gives that definitive outcome and reduces stress for all people involved. Prevents further harm to victims and witnesses because they don't need to go through the trauma of having to experience the whole trial and experience more stress and trauma, essentially. And the appropriateness of a plea negotiation. This is what questions will generally center around. Uh, as I've mentioned, the prosecution needs to approach the accused person and say, do you want to negotiate for a plea? They'll try to work out an agreement that is beneficial for the accused and for the prosecution. For the prosecution, it's beneficial to get the accused to plead guilty because then the case will be over. For the accused, they may be promised a reduced sentence. So they may be promised, if you plead guilty now, we'll knock off a few years off your sentence, right? So when is it appropriate and when is it inappropriate? Depends on the seriousness of the crime. If the crime is really, really serious, you might imagine it may not be fair to reduce the sentence of the accused because they've pled guilty. It may be more fair to not let them plead guilty and ensure that they can get the maximum sentence possible. It depends on the strength of the evidence. So if there's a lot of evidence to show that the accused really did commit the crime, and that is evident, it is highly appropriate to if there's lots of evidence against the accused, it's highly appropriate to potentially get the accused to plead guilty because it's already quite certain that they did it. If the accused is willing to cooperate and plead guilty, obviously they cannot be forced to plead guilty, and this is why this is really important. The views of the victim, if they wish for retribution, if they want to see the accused finally getting justice, being punished, they may not want a plea negotiation to happen. They want the trial to proceed. On the other hand, if they're really traumatized, they may just want the accused to plead. And there are possible adverse consequences of a full trial. So if it's not certain whether the strength we have is strong enough, the strength of the evidence is strong enough against the accused, if we proceed with a full trial, it may be that the accused is actually found not guilty. Okay? So this is why if there is a low strength of evidence, we may want the accused to plead guilty early as the prosecution to avoid those adverse consequences of a full trial, meaning a bad verdict as well. Sentence indications won't be assessed anymore as per the new study design. I've included it for your interest though. Still, this is the one slide that I did leave there because basically it's just to do with guilty pleas and plea negotiations. And it just explains that how does the accused know that they will get a reduced sentence? Well, they actually have to apply with the judge to get a statement that tells them how much of a reduction in their sentence will they get if they plead guilty right now. Okay? And that usually means before a trial. So you won't be assessed on this anymore, but for your own interest.